Be ready. Start. In the result, we deem it expedient for the ends of justice to allow these petitions. The only point that remains to be considered now is to which state the cases should be transferred. We are of the view that for the convenience of the parties, the state of Karnataka would be most convenient due to its nearness to Tamil Nadu. Accordingly, the petitions are allowed. CC number 7 of 1997 and CC number 2 of 2001 pending on the file of the 11th Additional Sessions Judge, Special Court number 1, Chennai, in the state of Tamil Nadu shall stand transferred with the directions that the state of Karnataka, in consultation with the Chief Justice of the High Court of Karnataka, shall constitute a special court under the Prevention of Corruption Act 1988, to whom CC number 7 of 1997 and CC number 2 of 2001 pending on the file of the 11th Additional Sessions Judge, Special Court number 1, Chennai, in the state of Tamil Nadu shall stand transferred. The special court to have its sitting in Bangalore. As the matter is pending since 1997, the state of Karnataka shall appoint a special judge within a month from the date of receipt of this order, and the trial before the special judge shall commence as soon as possible and will then proceed from day to day till completion. The state of Karnataka, in consultation with the Chief Justice of the High Court of Karnataka, shall appoint a senior lawyer having experience in criminal trials as public prosecutor to conduct these cases. The public prosecutor so appointed shall be entitled to assistance of another lawyer of his choice. The fees and all other expenses of the public prosecutor and the assistant shall be paid by the state of Karnataka, who will thereafter be entitled to get the same reimbursed from the state of Tamil Nadu. The public prosecutor to be appointed within 6 weeks from today. The investigating agency is directed to render all assistance to the public prosecutor and his assistants. The public prosecutor will be at liberty to apply that the witnesses who have been recalled and cross examined by the accused and who have resiled from their previous statement may be again recalled. The public prosecutor would be at liberty to apply to the court to have these witnesses declared hostile and to seek permission to cross examine them. Any such application, if made to the special court, shall be allowed. The public prosecutor will also be at liberty to apply that action in perjury to be taken against some or all such witnesses. Any such application will be undoubtedly considered on its merits. The state of Tamil Nadu shall ensure that all documents and records are forthwith transferred to the special court on its constitution. The state of Tamil Nadu shall also ensure that the witnesses are produced before the special court whenever they are required to attend that court. In case any witness asks for protection, the state of Karnataka shall provide protection to that witness. The special judge shall, after completion of evidence, put to all the accused all relevant evidence and documents appearing against them whilst recording their statement under section 313. All the accused shall personally appear in court on the date they are called upon to do so for answering questions under section 313 of the Criminal Procedure Code. A reading of the orders passed by the learned trial court on the applications filed by the present appellant as well as the two separate orders passed by the High Court affirming the orders of the trial court would go to show that the grounds that found favor with the learned courts to reject the prayer made by the appellant are largely similar. It is the view of the learned trial court as well as the High Court that in the present case the charges against the appellant were framed way back in the year 2007. At the time of the framing of the charge, the court is required to satisfy itself that all papers, documents, and statements required to be furnished to the accused under Section 207 CRPC have been so furnished. No grievance in this regard was raised by the appellant or any of the accused. The issue was also not raised at any point of time in the course of examination of any of the prosecution witnesses. Over 250 witnesses had been examined. It has also been expressed by the High Court that though the appellant had answered over 532 questions in her examination under Section 313 CRPC, no grievance was raised or any prejudice claimed by the appellant at any earlier point of time. Thank you.